Okay, so I think two topics are remaining. We'll just complete and we'll move to the new topics. Hope you got the handouts. No. Handouts दे दो जल्दी. Last class handouts you got, right? Okay. Okay, just a small request. So some students came after last class and said that I'm entertaining too much doubts in the class, which is generally not required. So there is some fact in it, because what I generally, it is not for the first time, what I generally observe is that there will be two types of doubts. One is very genuine doubts. Genuine doubts are also two types. One is because they did not study the static topics, so that doubt is coming. Genuinely it is coming. Second is while discussing something new, they are not able to understand, so they need an explanation or they are asking doubts based on that. But there is a third type of doubt, that is generally they know the answer, they are just asking the doubt after knowing the answer, either to tell the crowd that I know, do you know, or just to show that they know that. So we can avoid the second type of doubts, because you know, you don't need to ask that again and you don't need to show anything here. What you need to do is you need to show in the examination hall. Sometimes you will end up showing here and you may not end up showing in the UPSC examination. So I request you to avoid that, because PT classes be different from mains class. Mains we are having limited number of topics, but in topic we will cover multiple dimensions that is basically required for UPSC, that is what. But PT we need to cover more topics and we need to move from one topic, we need to hop from one topic to another. That is basically hopping. So genuine doubts also, I think if you want to ask in class you can ask, but we need to move ahead with the topic. And if you want to ask after class also, I will be available for half an hour after the class, you can ask. Okay. So I hope you are understanding the problem and I hope you will respond with sincerity and decorum of the class. Okay. So the topic is special address by the governor. क्या हुआ? अच्छा, हाँ ठीक है. So special address by the governor. So this is in news because of the various controversies, especially in opposition ruled states like Tamil Nadu, Kerala and West Bengal. So that is the main news, but you also need to know the same things are applicable to special address by the president. So governor's special address is given in the constitution under article 176. 175 is about communication between governor and the council of ministers or cabinet, and similarly 87 is special address by the president. So first we will discuss this, that is same there also. First one is, when does it happen? So there are two occasions. Special address by the governor or the president will happen in two occasions. First one is first session after general election. General election or state assembly elections. Second is first session in a year. These are the two times president or governor give a special address in their corresponding legislatures. Now, initially, in the initial days, president used to address every session. It was changed after the first amendment, and it was kept only in the first session after the general election and the first session in a year. President or the governor will address the legislature, their own corresponding legislature. Second is what will be their speech. What is inside the speech? So the speech is basically the policy and other aspects of the government. So the speech will basically contain what the government did in the previous year and what the government is planning to do in the upcoming year, coming year. That will be the general aspect. Since it basically governor delivers a speech that is related to the policy of the government, the speech is prepared by the government. Now what is the controversy is that sometimes the governors omits certain parts of the speech. This is what is becoming controversy. Now the second aspect is that, third aspect is that after the speech, these are constitutional dignitaries, head of the state or head of the, like president or governor, both are head of the states. So there is a motion of thanks, thanking the head of the state. So there will be a motion of thanks, and this motion of thanks has to be passed. It has to be passed in the case of president, Lok Sabha, or in the case of governor, state legislative assembly. If it is defeated or if it fails, it will be considered as the defeat of the government. Defeat of the government, that means it is similar to confidence motion. Confidence motion. One more point to be noted here is that in the case of president or governor, if there is a state legislative council, governor will address both together. They will sit together and they will be addressed together. Similarly, president will address Lok Sabha and Rajya Sabha together. He will be addressing this together. If there is a dissolution of Lok Sabha, then president may not address the session. Only after the commencement of the new Lok Sabha, president will be addressing it. So this is also another important MCQ trap. So these are the things related to this topic. Okay. So same thing with respect to governor as well as president. Only the difference is that president, generally there will be both the houses. Here there will be very few states constituted state legislative councils. Okay. Any doubt? If there is genuine doubt, you can ask. Now there is no doubt. So you don't need to address that time. Only after the commencement of the new Lok Sabha, both will be sitting together and president will be addressing it. That is what I said. Here there are two options. One is first session after general election. So after the dissolution, a new Lok Sabha will be constituted, president will address both. One more a complexity is happening now, especially in the case of governor. 176 says, governor shall address. That is the word used in the constitution. Governor shall address. Governor shall address means it is a both president as well as governor shall address. So it is basically a mandatory provision. But there are certain incidents now, governor is not even addressing it. So according to PDT Acharya and all constitutional experts, it is actually goes against the constitution. So Karnataka already took the matter to the court. So we don't know what Supreme Court will say. As per the constitution, it is mandatory. No doubt in that. The word used in the constitution is shall. I'll just read that. At the commencement of the first session after general election to the legislative assembly, this is exact wording from the constitution. At the commencement of the first session after general election to the legislative assembly and at the commencement of the first session every year, governor shall address. Governor shall address. So that is basically the word. That means it is a mandatory provision. Constitutional experts also says that it is mandatory. But matter is anyway in front of the Supreme Court. Karnataka took the matter to the court. We'll see what is the final decision later. But that is the present situation. Now the problem generally what happens is that if question comes, what will happen? So if question comes whether governor is having limitations or not, governor is acting aid or advice, lot of confusion, especially 16th presidential reference and all. So you remember what is the judgment, that is state of Tamil Nadu versus governor of Tamil Nadu case, that is actually the judgment. Question if at all is coming, UPSC will put with respect to 16th presidential reference, which of the following statements are correct. So don't worry about okay which will be correct, which I need to make it correct or wrong and all. You make it correct as per the demand of the question. The question will be more specific in the case of UPSC. I don't know about test series. Next topic. Article 356 of the Constitution. So this is popularly called as President's Rule, or it is also called a state emergency. But what Constitution says? It is constitutional breakdown. Constitution calls it constitutional breakdown. Constitution does not use the word emergency, President's Rule, etc. It basically says that it is a constitutional breakdown. That is the first thing. Failure of the constitutional machinery. It is inspired from section 9 of Government of India Act 1935. It is inspired from section 9 of Government of India Act 1935. Second is the grounds for President's Rule. So there are two grounds. One is a direct ground, another one is an indirect ground. Direct ground and indirect ground. So direct ground, it says that if president is satisfied based on a report from the governor or otherwise, that means without report also. President is satisfied based on a report from the governor or otherwise that state government cannot be carried out in accordance with the Constitution. That is the first aspect. Second is the indirect aspect. If the state fails to comply with a constitutional direction given by the center. If state fails to comply with a constitutional direction given by the center. These are the two grounds. Second is checks and balances. So Constitution is not giving a complete powers to the executive. There are a lot of checks and balances. So what are the checks and balances? First one is there is a time limit. There is a time limit. What is a time limit? It has to be passed within 2 months by the Parliament. It has to be passed within 2 months by the Parliament. That is, both the houses has to be accepting or approving it within a period of 2 months. That is the first thing. Second is majority. What majority? It has to be passed with a simple majority. Third one is the duration. If President's rule is declared, it will be in place for a period of 6 months at a time and maximum of 3 years. But there is one more clause. After 1 year, it has to satisfy 2 conditions. What are the 2 conditions? 2 conditions. First one is, if there is a national emergency in place across the country or in that region. Second, election commission says that election could not be completed or conducted in that particular state. If election commission says that it cannot be completed or conducted in that particular state. So this is the things. This is added through 44th Constitutional Amendment 1978. 44th Constitutional Amendment 1978. Third aspect is the consequence. Consequences of 356. First one is, President will dissolve the, initially what generally happens is suspension. Then after approval, President can dissolve it. Then automatically the executive powers will go to the President, and on behalf of President, Governor will take up the executive actions. The legislative action will go to Parliament. Parliament can even enact state budget. And if Parliament want, Parliament can delegate the lawmaking power to the President. So that is why it is called as President's Acts. President's Acts. Third is judiciary, no change. No change to the judiciary. So these are the key consequences. There is no change to the judiciary. Similarly, there is no change to the fundamental rights. Nothing changes under the President's rule. Then with respect to fourth aspect, that is judicial review. Judicial review, power of judicial review. Is there any judicial review? Yes, Supreme Court can examine if the material behind the President's rule, that is bona fide or mala fide. If there is any arbitrariness, that can be checked by the Supreme Court. So Supreme Court can examine if the material behind the decision, whether it is having any mala fide intention or not. If it is in good faith, no problem. But if there is any other mala fide intention, then it's under judicial review. So these are the things with respect to 356. So there are basically 4 heads. First one is the grounds, second is the checks and balances, third is the consequences, fourth one is the judicial review. Questions are also coming from these things. What condition? What can be? After suspension, automatically the approval comes, then it can be dissolved. Means President cannot dissolve. Parliament's approval is required. Once the approval comes, it can be dissolved. And the maximum period is 1 year. In the case of Manipur also it happened before completion of 1 year. Now it is revoked. Now it is revoked. So these are the things. Now we will move to one more topic in executive, that is Attorney General. Attorney General is also a favorite topic of UPSC. So Office of Attorney General is established under Article 76. Article 76 of the Constitution. Attorney General is the highest law officer. Highest law officer of the country. Highest law officer means Constitution establishes this office. Constitution establishes this office. That is why it is considered the highest law officer. And government, this is established. Why this is established? So that government receives independent legal advice. That is basically objective of Article 76, or setting up of a separate office for a law officer. So he is the highest law officer, or he is also the first law officer of the government. There are also other law officers like Solicitor General or additional Solicitor General. These are not mentioned in the Constitution. Only AG is mentioned in the Constitution. Next is appointment of AG. AG is not elected. AG is appointed. There is nothing like election of AG. The government of the day will appoint him, and he is appointed by the President of India. He is appointed by the President, and he will remain until the pleasure of the President. Means he can be removed by the President. But he need qualification. What is the qualification? Qualification is that he should be qualified to be appointed as a judge of Supreme Court. He should be qualified to be appointed as a judge of Supreme Court. So whatever the qualification required to become judge of the Supreme Court will become the qualification for AG also, same qualification. So remember that he does not have any fixed term. Well, like judges, he does not have any such security tenure. He can be removed by the President at any time, pleasure of the President. That is it. Next is, another key aspect is that conventionally, Attorney General resigns when Council of Ministers resigns. It is a convention. These are the traps. When I am repeating it, you also underline it twice. Conventionally, AG resigns when the Council of Ministers or the government resigns, or if the government is replaced by another government, then conventionally he resigns because he is appointed by that government. That is the reason. His salary is not fixed by the Constitution. Not fixed by the Constitution. So he receives salary as the President may determine. It is not fixed by the Constitution, it is decided by the President. His duties or functions of AG. So the major function, he provides legal advice to government of India. So I give advice to government of India on legal matters. That is his primary function. He will represent the government. He will represent the government in courts on behalf of the government. He will represent the government. Similarly, he will represent the government in presidential references also. He will be representing the government in any reference made by the president under Article 143. He can also appear in any high court if required by the government. Next key aspect is that he enjoys certain rights and privileges. This is a typical UPSC area. He enjoys certain rights and privileges. So under Article 88 of the Constitution, under Article 88 of the Constitution, the AG, Attorney General, has the right to speak and take part in the proceedings of the Parliament. Right to speak and take part in the proceedings of the Parliament at both the houses. He can also participate in parliamentary committees or in the committees in which he is a member, or he can participate in joint sittings. But remember, he does not enjoy any right to vote. He does not enjoy any right to vote in these committees. No right to vote. So he enjoys all immunities available to an MP. All immunities available to a member of Parliament. Next is another key MCQ trap is to avoid conflict of interest. AG is the first legal officer, but there is one option for him. He can do private practice. He can continue with his private practice if required. Recently it was in news, the AG was not available because he was representing in an international arbitration. So court said that your first duty is your constitutional duty, then comes your private duty. But that also means that there is no restriction, ban for any private practice. Because of this, there is a possibility that there can be a conflict of interest, since he also does a private job. So what is the key aspects to that? There are certain limitations. The first one is that he cannot advise against the government. He knows something about the government, he takes a case and he says that ये सब कर लो, मुझे सब कुछ पता है. He cannot advise against the government. Second, he should not defend an accused person in criminal prosecution without the approval. That is important. He can, if there is a government sanction, government approval. He cannot defend a criminal accused person in a criminal case without the government's permission. Without the government's permission. But remember, he is not barred from any private practice. That means he is not a full-time government servant. So these are the things. Yes. Next is, we are moving to legislature. First topic is with respect to Jammu and K Union Territory of Jammu and K Legislature. Union Territory of Jammu and K legislature. So this is also very significant development in India's overall federal structure. So Ministry of Home Affairs filed an affidavit in the Jammu Kashmir High Court which is related to the power of Lieutenant Governor LG of Jammu and Kashmir. So that is basically the matter. So according to no, anything against government is not allowed. That is what the government won't give a permission in that case. Very simple. He need a permission from the government to appear, but he can appear if there is a permission. But generally, if the matter is against government, he is not. He cannot also. Government won't give permission also. What we are discussing? What? Yeah. So according to Jammu and Kashmir Reorganization Act 2019, later amended in 2023, Jammu Kashmir Reorganization Act 2019, which is later amended in 2023, it says that Jammu Kashmir has 90 elected seats. Elected seats of the assembly is 90 elected seats, but it also kept some seats for Pakistan occupied Jammu and Kashmir, because we'll take it sooner or later. We ordered some Rafale. Okay. So it is already kept in the law itself. Certain number of seats, I think around 24 seats are kept for that, for the regions which is presently under the Pakistan occupied area. So there is total of 114 seats around in Jammu Kashmir. This plus, it also says, the same act under section 15 says 5 members can be nominated by the LG. 5 members can be nominated by the LG. So remember, this is the elected, the total is the sanctioned strength. So elected strength is 90, but the sanctioned strength is the total. That is whatever is kept for POJK plus the nominated members. Who will be nominating them? They will be nominated by the LG. Now why there is an affidavit in the court? Because these even nominated members will have the same voting rights. So there is a concern that if there is a hung assembly, LG can nominate 5 people and take control of the government. So that is why there is a concern, because even voting rights is granted to the nominated members. That is why it is news. But the view of MHA is that LG nominates these members not based on the aid and advice of the Council of Ministers, but in his discretion. He nominates them in his discretion. So he can nominate 5 members. These are 2 women members, 2 Kashmiri migrants, and 1 member displaced from POK. These are the 5 members, 2 women members, 2 Kashmiri migrants, and 1 member displaced person from Pakistan occupied Jammu and Kashmir. So that will be according to the status given by the government. Government will be giving a status. Based on the status you will be getting it. That is already there. Even before that also it was allowed. If you are migrator, still you had some certain rights under 35A also. So it will be basically something which is granted by the government. So the main point here is that it is done not based on the aid and advice, but LG's discretion, plus nominated members enjoy voting rights. The total sanction strength include all these things. One more thing is that the same provision is applicable in Pondicherry also. Jammu Kashmir legislature is constituted similar to the way Pondicherry legislature is constituted. A similar thing is applicable in Pondicherry. There is a provision for nominating 3 members by the governor. By the Lieutenant Governor, there is a provision to give nomination for 3 members. Same thing is there. Such a nomination provision is not in Delhi. In Delhi, which is also UT Union Territory with the legislature, it does not enjoy any such, or the governor, Lieutenant Governor of Delhi does not have any nomination provision. But Puducherry and Jammu Kashmir is having, because Jammu Kashmir is constituted on the lines of Puducherry. So that case is, if you want, just you can remember that for your mains purpose also, PT is not required. That is Lakshmi Narayanan versus Union of India case. That is given in your handout also. 7th point. Lakshmi Narayanan versus Union of India case. Supreme Court upheld the Madras High Court decision that in Puducherry, the administrator could nominate members without the aid and advice of the Council of Ministers. Exactly, they will be getting the benefits. They are having similar powers like a regular legislature. That's it. No. Regular. They are like a member. All similar to the other elected members, they also enjoy the same power. Next is speaker's removal. Am I going fast? Yes or no? Thank you. I thought I am going fast. No. Court said the same thing. Center can nominate in the case of Puducherry. MHA quoting the Supreme Court judgment only said that this is a statutory power derived from Jammu Kashmir Reorganization Act, which is already upheld in the case of, say, similar power is already upheld in the case of Puducherry. So same only. Next is removal of speaker. It's in news because opposition, especially Congress party, is thinking that they can remove the Lok Sabha speaker. So that is why it is in news. So first, Article 93, constitutional aspects. Article 93 of the Constitution says that Lok Sabha shall choose 2 members to be speaker and deputy speaker. And Article 94 deals with a vacation or resignation or removal of speaker. Removal of speaker. So speaker is an important office in India's constitutional scheme of things in the parliamentary system. He is not just the presiding officer, but he is the guardian of the MP's privileges, protections, and also to upkeep the house dignity. So he is having a specific roles and responsibilities. So first one is the office of speaker. So 93 we discussed. So election, speaker is chosen by the Lok Sabha from its members, from its own members. What Constitution says is that speaker has to be chosen amongst its own members as soon as possible. Our Constitution is famous for these things, as soon as possible. Okay, so speaker is chosen by the Lok Sabha from amongst its own members as soon as possible. That is a clause. And what is his tenure? What is his term of office? He remains during the life of the Lok Sabha. He remains during the life of the Lok Sabha with a crucial exception. He remains during the life of Lok Sabha plus if the Lok Sabha is dissolved, this was the last year's question. If the Lok Sabha is dissolved, the speaker does not vacate her office immediately. It does not vacate his office immediately. He continues until before the first meeting of the new Lok Sabha. He continues until before the first meeting of the new Lok Sabha. Means that office will remain functional. Office will remain functional. See, that is what I am saying. He is having the power up to selecting the pro tem speaker. He will be running it. Next is, what are his functions? What are his functions? So major functions: regulating the house, order and decorum of the house. Regulating the house is his major function. And he also enjoys casting vote. Means he may not vote at the first instance. He will vote if there is a tie. Casting vote if there is a deadlock. So he may not vote, this is important, he may not vote in the first, this letter you will get why this is important. He may not vote in the first instance, he will vote if there is a deadlock. Second major function is, he enjoys certain, this is about regulating the house, certain special functions or special powers, exclusive powers, which is not enjoyed by Rajya Sabha chairperson. That is, he certifies money bill. He certifies money bill and he presides over joint sitting. Certification of money bill and he presides over joint sitting. He presides over joint sitting. This is exclusive power of speaker. Plus he also enjoy another major power is under disqualification. Under disqualification, under anti-defection law, speaker decides on disqualification of member. Under an ADL, speaker decides on the disqualification of a member. Next is, he appoints committees. Appoints committees, chairmen of committees. He himself is chairman of certain committees like Business Advisory Committee. So these are the general things. What is important for us is removal. So removal of speaker. The process is governed by rules of procedure of Lok Sabha. Rules of procedure of Lok Sabha. So first is, so there are, I'll discuss in a sequential order as per the rules of procedure. Rules of procedure is given under rules 200 to 203. Rules 200 to 203 of Lok Sabha rules of procedure discusses this. These things are now coming in UPSC prelims because UPSC exhausted the previous questions. No, that is the reason. This kind of questions UPSC may not even ask because this is available in Lakshmikant and things like that. But other than this, specific things are being asked by UPSC, which is maybe in rules of procedure or that particular specific law. So first one is, I will discuss in sequential order. First one is the notice. Under rule 200, notice. So any member of the Lok Sabha can give a notice. Any member of Lok Sabha can give a notice for the removal of speaker. Similarly, deputy speaker, both are same. The process is same. The notice must be given in writing, not WhatsApp message, in writing to Lok Sabha Secretary General. Lok Sabha Secretary General. There is a timing, there is a 14-day rule. A 14-day rule is there, which says that the motion can be taken only after 14 days have passed. Motion can be taken only after 14 days have passed from the date of notice. So that is first aspect. Second, this is Roman letter I am keeping. Second is admissibility. First one is a notice, second admissibility of notice, that is given under rules 200A. So notice is not automatically accepted, it must satisfy certain conditions. So first condition is that the notice should be with the specific charges. You cannot say that I saw the speaker in CP. There should be specific charges. Or you cannot say that I don't like the speaker, so remove him. So that is the first key aspect. It must satisfy such conditions. It should be very clear. Notice should be very clear. You tell what are the specific charges, then only it will be admissible. Next is house, roll of house. Roll of house. So if the removal, who will be the presiding officer? Yeah. Speaker cannot preside, so automatically deputy speaker will be the presiding officer. Second, there is a test. So speaker cannot preside, automatically deputy speaker will be the presiding officer. There is also a test, that is 50 members. If 50 members or more supports the motion, then the permission is granted. Next one is the fourth stage, that is the schedule, the final schedule of the debate about the motion. So that is under rules 201, 202. So once the permission is granted, the discussion must be taken up. The discussion must be taken up on a day fixed by the presiding officer. Discussion must be taken up on a day fixed by the presiding officer. And this day must not be more than 10 days. Must not be more than 10 days from the permission granted. And the discussion has to be strictly based on the specific charges. Then comes the removal process. What sort of majority is required? Effective majority is required. The majority required is effective majority. All the then members of the house. Effective majority. And here speaker can vote, but not like casting vote like any other member. Speaker can vote, but like any other ordinary member, not like a casting vote and all. First instance he can vote. So this is the removal process, but speaker also can resign. How he can resign? Give the resignation to deputy. And how deputy can resign? Very good. Then the next person will be, you can put a, yeah, panel. Yes. So these are the key things with respect to removal of speaker. To move the motion, 50 member support is required. But to take it, you need a support that okay, this many members are supporting that particular motion. What is the address? What? Secretary General, yes. The notice will be, see, all such things will be generally submitted to Secretary General. No, you submit it, then you need to go through this process. If 50 members are supporting it, then the presiding officer will grant the leave. Then based on that, after you will fix a date. Within the 10 days of the date, you need to conduct it. And you move the motion based on the effective majority. Pass it. It is just you submit. To whom you submit, there should be a permanent person, right? That permanent person is that. But it will be taken up by the house. Automatically he will be the presiding officer now. So he will be taking it if there is a 50 member support. He will have to. If there is a 50 member support. No, Secretary General is just a permanent employee. He does not have any other power. He is basically kind of an employee who will take up these kind of notices. He is the office. That's it. No, he is not that will happen in this process. If there is less, see now what will happen, there won't be 50 members backing the removal. It's gone. It is notice, not a motion. The first notice, okay, I don't like the note, I can't say that. Whatever be the reason, he did this in the house, so I want to remove that first level of notice, that's it. No, it is just a notice that doesn't mean that it is admissed. It is taken up. Admissibility happen later. Here. No. Notice is just given. Now also notice is given. That's it. Notice is given that I want to remove. I don't like. It is not clear PT. That's it. Simple. No. Next level, when the matter is taken up. No, he will just take up the notice. That's it. He is just a normal, a bureaucrat. That's it. Okay. The admissibility comes when that 50 members supports. 50 लोग आके बोलम हमें चाहिए कि चाहिए. Then presiding officer says okay 50 लोग है, हाथ उठा करो, काउंट. चलो ठीक है. सेक्रेटरी जनरल से इधर मुझे एक नोटिस मिला है, आपको चाहिए या नहीं, बस. और क्या करेगा वो. Next topic is, which is the next topic? Very good. Deputy Speaker. So similar to the Speaker's office, Article 93 also mandates the office of Deputy Speaker. But there is an interesting thing, first time in India's political history, that there is no Deputy Speaker. No Deputy Speaker in Lok Sabha, the position is remained vacant. So what are the key aspects that we'll discuss? So 93 says that, the Constitution says, 93 says, they shall choose 2 members to be Speaker and Deputy Speaker as soon as possible, or as soon as may be. That's it. That is basically the idea. Again, no time limit is prescribed here. So, House shall choose a Deputy Speaker. That means what? It is a mandatory language. House shall choose. So this means it is actually constitutionally it is mandatory without any time limit. You need to do it, but no time. Likho means PT bar. No time limit. Okay. I forgot to take my coffee, yeah, because of I want to finish the topics, nothing else. Okay, so that's it. So there, like Deputy Speaker is also elected by the Lok Sabha among its members, same like Speaker. But what is the timing? Election take place after the election of Speaker. You cannot select Deputy Speaker first. Vice captain is not selected first, captain is selected first. Okay. Now, date of election is fixed by Speaker. Date of election is fixed by Speaker. Similarly, he also remains in the office till the life of Lok Sabha, that is 5 years. Or he can resign also. He can resign by submitting his resignation to Speaker. Or if is not both the case, if they are ceased to be a member, then they will cease to be a Deputy Speaker also. Or he can be removed by a same resolution. But do remember that Deputy Speaker is not subordinate to Speaker. Deputy Speaker is not subordinate to Speaker. These are the things. Who fixes the date for election of Speaker? President. That is the MCQ trap. Date for speaker is fixed by president. Date for deputy speaker is fixed by speaker. Now there is a convention. It is not in constitution. The convention is that parliamentary convention from the Morarji Desai days. The deputy speaker's post is given to opposition. That is why there is no need. So these are the simple things. हाँ उसको क्या प्रॉब्लम है? Term is, if he is a member, if he is not a member, then his term is over. If he is a member, he will remain till the life of the Lok Sabha. Same. क्या हो गया? नहीं, no, that is for the speaker. He will remain till the life of Lok Sabha. Okay, so these are the key of things. Next is new attendance rules in CAVA classes. हाँ जी. He will automatically become the chairman. He is automatically become the chairman of that member. It is not in constitution and all. Constitution is not saying those things. What is the topic we are discussing? Not CAVA. CAVA also we need to fix something like this. What I am saying is that PMT there is a less attendance, and class there is more attendance. That I like, class more attendance, but PMT also I need more attendance. Otherwise what will happen in the original exam hall, you will remember that song. Tu pyar hai kisi aur ka tum chaho. When you mark B will be somebody else. You basically should have marked C. That will happen. So attend this properly, otherwise it will go to somebody else. Okay. Attendance rule is mandatory now. In PMT also we need to see the what? Jokes, no. You can say it loudly. Everybody enjoys. TADA also. Where? अच्छा दे दूंगा क्लास के बाद मिलना ठीक है both TA and DA in detail. So this is some new digital rules in Lok Sabha, a new mechanism which is basically e-attendance. E-attendance. So here also there are few important MCQ traps, otherwise the topic is simple, nothing is there. So it is introduced last year. Lok Sabha introduced a digital system to mark attendance. Digital system to mark attendance. What is the system basically? It is a like a tablet normal system. So how an MP can mark attendance? MP can mark attendance multiple ways: by scanning their ID card or through thumb impression biometric authentication. These are the methods he can mark or sign the multimedia device or tablet. Previously, the location for attendance, this is the major change. Previously, the location for attendance was in the lobby. There will be a register, you sign it, and you immediately you will go back. You just sign it. Now this is introduced, you need to be in your seat. In that seat, this particular tablet or that device will be there. You need to mark your attendance by sitting there. So this is a major change. Now what is the reason for this change? The major reason cited are, first one is to increase the efficiency, overall efficiency, and also to encourage that MPs actually participate in the house rather than sign and leave. It also part of digital integration, paperless Lok Sabha, digital integration. And above all, it is important to receive the allowances. You will receive the allowances based on your attendance. Attendance is also important, that we'll discuss. If a member is not attending it, then there is a provision for removing him, that we'll discuss, 1014, we'll discuss later. So that is also reason why it is important. Other than the rhetoric ideas, this is important. Allowances plus attendance is also required, that is 60-day attendance is minimum, continuous attendance is required, that is also there. But what is the MCQ trap here is that ministers and leader of opposition, they are exempt from signing in. They are exempt from the signing in. But it is compulsory for MPs to mark their attendance if they want to receive the daily allowances. Presently the rule is applicable to Lok Sabha. Rajya Sabha is yet to start it. And it is based on Article 118 of the Constitution, which deals with the conduct of business in House. Similarly, you can mention here 101 clause 4, we will discuss that later. Article 101 clause 4. If an MP is absent from the house for 60 days, 60, MP is absent for 60 days without the permission of the house may declare their seat vacant. However, the 60-day count excludes the days when the house is not in session, prorogued or adjourned, not in session for more than 4 consecutive days. First one is 101. If MP is absent from the house for 60 days without house permission, house may declare the seat vacant. How you will be calculating the 60 days? The 60 days excludes the days when the house is not in session for more than 4 days without the permission of speaker. Means house in the sense there is a committee, you can convince in the committee also, that is why it is said house. Next is parliamentary procedure or rules in use. Lok Sabha, specifically rules of procedure of Lok Sabha in use. First one is rule 349. You just need to know this for a match the following kind of questions. Rule 349. It was in news because the leader of opposition read some book, some parts of some book. Okay. Yeah, you know everything, I know. These things you will be knowing. So 349 says that members are strictly prohibited from doing certain things to ensure that the debate remains focused. The debate remains focused and the chair is respected. For example, this 349 talks about respect for the chair, that is respect for the speaker. For example, when a member enters, member should respect the chair. Okay. Next is they should maintain decorum. They should maintain decorum. These things are not practiced. And then there is certain prohibited things, prohibited activities. One such activity under 349 is members cannot read books, otherwise also they are not reading. Members cannot read books, newspapers or letters unless they are directly connected to the business of the house. Can they use any kind of badges? Badge. Can they use? This will be confusing. If at all there is one question on 349, otherwise you can easily eliminate. You cannot read everything 340. Now you are opening rules of procedure 349. Wow. No smoking, no electronic device, this, that. You don't need to. Otherwise also smoking is not allowed. So you can eliminate. They are not allowed to wear any badge other than national flag. Next is 352. So 349 talks about how you need to behave in general. 352, what member cannot say. What member cannot say, that is puts a boundary on freedom of speech and expression. It puts some boundary on the freedom of speech and expression. So first one, under 352, there should be a respect, especially high officers and the judiciary. Respect on high officers and judiciary. But they can be discussed if there is a specific procedure for that. Without that, for example, judges removal, you can discuss that. Okay. Similarly, no defamatory words or sedition, defamatory words or offensive words or unparliamentary. That is why sometimes you can see that, I think last year I think this happened. Parliament released a list of unparliamentary words which you cannot use it in the parliament. So some words like sedition, which may lead to sedition. So that is why now there is a allegation against one member that he is using such seditious words in the house. Now the 352 is also in news. From yesterday onwards it is in news. Similar to MPs, you also won't read newspapers and any books. So you may not be knowing it. So this is 352, 353. It governs how an MP can make allegation which is defamatory in nature against any person on the floor of the House. Means MPs cannot make some allegations, they should follow a procedure. What is the procedure? If they want to make an allegation against minister or any person on the floor of the House, then you need to get a permission. Without permission, you cannot make whatever statement you want against the minister or a person on the floor of the House. And here speaker is having a veto. Speaker has the authority to stop the allegation. He may prohibit. So that is why sometimes we can see, if you watched Parliament live, you should watch, very interesting. It is similar to a stand-up. You will get a lot of funny things. So sometimes you know now 314 and 352, when you see that you will think, yes, ab kya hai? No 349, no 352. Okay. They will all come under, actually what happens, they will all get the benefit of parliamentary privileges, that's it. But these are also the rules. So 352, 353 and 362. It empowers the House to cut short a debate and move immediately to vote. 362 empowers the House to cut short a debate and move immediately to a vote. So this is basically used to prevent members wasting time. Then comes 380. 380 empowers the speaker with the power to expunction or deletion. Expunction or deletion of words which are unparliamentary or defamatory in nature. So that means it was removed from the records. These words are removed from the records. Authority is speaker. So all these powers are generally from Article 118 of the Constitution. Next is committee news, that is Joint Parliamentary Committee. So Joint Parliamentary Committee is a temporary or ad hoc committee Joint Parliamentary Committee is a temporary or ad hoc committee established for a specific purpose or to investigate a specific case or bill. Established for a specific purpose. It can be for a particular matter, a particular case, or a thorough examination of a bill. No, expunction is basically, see, it is records. Records also, what will be there if there is a word, you are an MP, automatically you will use also a word. Okay, you said something, but in records what will happen? There will be like this, and in the bottom, expunged by the chair. So tomorrow, if the records are coming, public or you, that won't be there. You are listening that, but it will be deleted. At least future generation will be better. Anyway, you people are not. Huh? Yes, speaker. He is obviously presiding officer, speaker. So there is a panel. Next person will be there, next deputy will be there. If deputy is not there, another person. There is a panel of 9 members. Yes. No. Sometimes what will happen if somebody says that from the treasury bench itself there will be demand for deleting it. Which one? If he is, any immunity, any rules, if he is participating in the house, it will be applicable to anyone. Exactly. That is the rules of procedure. 1118 says that the parliament is a big thing. Constitution cannot prescribe all the things. Otherwise itself our constitution is big. So constitution said that baki ek dusra book bana lo. So that is rules. How the conduct of business, what is happening in this. Many things will happen there. It will be discussed under the rules given for Lok Sabha. It will be different. Rajya Sabha it will be different. Okay, so JPC is ad hoc committee or temporary committee constituted by the parliament. So it is not permanent in nature. It is not having a continuous work. It is not standing. So it will cease to exist once it completes that particular task, specific purpose. So it can examine either a bill or investigate a specific matter. Inquire, investigate a specific matter. It includes, as the name suggests, joined, that is members from both the House of Parliament, Lok Sabha and Rajya Sabha. Its formation, in general it is formed through a motion, and this motion will decide the number of members also. By moving a motion, it is formed, means it is not automatically formed. You need to go through a process. The process is to move a motion, and who will move the motion? In the case of bill, whoever is presenting the bill, he can move. For example, if minister is presenting a bill, DPDP, Waqf Act, whoever is presenting that bill, he himself can move a motion for JPC. So who is in charge of moving that bill, he will be moving the motion, or it can also be constituted by the speaker. Second, so this is the first aspect of the formation. Second step is there has to be a concurrence. Means motion moved by one house concurred by the other. When the motion is moved, can the members propose any amendments? Members can propose amendments. So now there is one thing, speaker will constitute a JPC when it is generally related with a inquiry before scam. Some inquiry is there, some scam is there, some investigation is required. In that case, inquiry committees are generally constituted by the speaker, but bills, advisories on these bills, it is generally based on a motion moved by the member who presents that particular bill. So there is no fixed numbers of the members, it will be based on the motion. The powers and functions of JPC. Powers and functions. See, there is two types of things generally JPC inquires in India's case. One is some kind of scams or investigation on some inquiries. Such JPC, for example, inquiry on before scam, such a JPC can be constituted by the speaker. But if there is a DPDP bill, Waqf bill, simultaneous elections bill, these are certain bills, it will be generally, this bill will be moved by a government member, a minister. So the minister himself will propose motion. Next is powers and functions. No, that in that case speaker can also form a JPC. Obviously, when it is formed, there is no fixed number for JPC. It's not like public account committee, there is 30 members, nothing. It may vary from, generally it is 2:1, but it also varies. No, it will be decided through that particular speaker's case. Powers and functions of JPC, one is examining, for example, a bill in detail, scrutiny of a bill. It can also, committee also has the power to collect evidences, evidence collection. So for that they can even call experts if required. Then committee submits its report to the House. Examining the bill close by close. For evidence purpose or examination purpose, it can consult various stakeholders, experts. Third one is submit, after all these things, submit the report to the House. What about its suggestions, recommendations? Recommendations are not binding on the Parliament, House. What about money bill? Yeah, money bill cannot be referred to a joint committee because Rajya Sabha is not having any role in money bill. These are the key aspects. Next is delimitation commission. Again a typical UPSC question. So first one is, what is delimitation? I'm very happy that we are able to move very fast. You are, yeah. No, you can ask doubt, okay. Absolutely, there is no problem. The only thing is that don't ask 352. That's it. Otherwise, you can, whatever doubts you are having, you ask, no problem. So next is delimitation. So delimitation is the act of redrawing the boundaries of constituencies. Act of redrawing the boundaries of the constitution, that is delimitation. So what is the objective of this? It is a Yes, that is joint. Joint parliament is what? You thought something else. Delimitation. The objective is to ensure that the ratio between the number of seats and the population is same for all constituencies as far as possible. It is not possible in India, so as far as possible. Okay. The ratio between number of seats and the population is same for all constituencies as far as possible. This particular objective is to ensure what? Yeah, one person, one vote, one value. Most important principle of a parliamentary or representative democracy. Now, according to the constitution, delimitation should happen after every census. This is what constitutional mandate. According to constitution, it usually happens after, or it should happen after every census. So Article 82 of the constitution, mandates this. Article 82 of the constitution mandates that after every census, the parliament must enact a delimitation act. Do remember Article 81 also? Article 81 of the constitution, which deals with the composition of Lok Sabha. 81 deals with the composition of Lok Sabha, and this composition is adjusted based on these changes. 81 deals with the composition of Lok Sabha, and the composition is adjusted based on the changes. So what is basically the chain of action? First one is census. After that, Act of Parliament. And based on this Act of Parliament, Delimitation Commission is established. It will come up with its formula, whatever method, and then a redrawing of boundaries. This is the chain of action. Census, so you collect the population data. Now you know the population is different, so Parliament will pass a legislation. Based on that, Delimitation Commission will be constituted, and this will come up with its formula, its method of redrawing, and based on this method, constituencies will be redrawn. That is a process. So what the constitution says is basically upon completion of every census this should happen. But in India's case, the same thing is applicable in the case of state. Under Article 170, the same thing is applicable. And Article 327, empowers Parliament to make laws regarding delimitation of constituencies. Since the constitution gave the power to the Parliament till now enacted, this was a previous question, for delimitation commission acts 1952, 62, 72 and 2002. So till now Parliament enacted 4 Delimitation Commission Acts 52, 62, 72 and 2002. So once it is enacted, second aspect is composition. Composition of the Delimitation Commission. It comprises of a chairperson who is retired or serving, Supreme Court judge, chairperson, retired or serving Supreme Court judge, and members will be Chief Election, ex officio member will be Chief Election Commissioner, Chief Election Commissioner of India, plus there will be State Election Commissioner of the concerned states. There is also provision for associate members. Associate members. Other than this, there is also provision for associate members. So MPs or MLAs can be appointed as associate members, but they do not enjoy any voting rights. They just assist the commission. They do not enjoy any voting rights. But remember that the core commission is basically judicial in nature. The core commission is this, judges, and means judicial plus the election role of administration. This is in nature, there is no political aspect. This maybe associate members can be appointed, they just to assist, they cannot force the commission to redraw based on their priorities, nothing. Next is the freeze on delimitation. The freeze on delimitation. So 42nd Amendment 1976, frozen delimitation until 2000 based on 1971 census. Later 84th Constitutional Amendment, 84th Constitutional Amendment Act 2001 extended the freeze until the first census after, this is important, until the first census after 2026. It does not mean that it is in 2031. Whenever this happens, until the first census after 2026. So now we are already, this is also important topic for you. We are already going for census. So after that it will be constituted. Then there is one more amendment, that is 106th Amendment. This is for 1/3 seats reservation for women, and this reservation for women will be applicable after the delimitation happens, after the next census and delimitation. So this was a previous question. After the next census, maybe like 2027. Now it is, there is certainty. Before that there was no certainty. So whenever the next census happens, after that delimitation, then only this will be given, 1/3. Okay. So these are the key aspects. So now it will be 5th delimitation after the census. So remember, delimitation commission is a statutory body and it is not permanent, it is an ad hoc body. Yes, state will also do the same thing. Exactly. J&K, the delimitation, sorry, there is two things here, not only J&K, northeastern states also. Here, during the 2002 delimitation, because of the various issues, delimitation could not be completed here. So later, the delimitation conducted here. Jammu Kashmir delimitation is happening under Jammu Kashmir Reorganization Act, because it is completely reconstituted. So the act basically provides for delimitation of the Jammu Kashmir constituency. So that is why sometimes you can say northeastern, Assam it is different, because it is in protection under Assam Accord. So northeastern states, Assam, you can sometimes see that delimitation happened later. That is correct, but it is basically based on the 2002 only. There is no such thing, but it constituted later to do the delimitation, because that time they could not conduct that. Jammu Kashmir it is different, because it is happening under Jammu Kashmir reorganization. And next is, the orders are laid before Lok Sabha. Delimitation orders are laid before the Lok Sabha. Can Lok Sabha modify it? Lok Sabha cannot modify, or state assembly, Lok Sabha cannot make any modifications. What about election commission? Can election commission make any changes to the boundaries? Election commission also make any changes to the boundaries defined by delimitation. Now recently there is a interesting thing, because delimitation commissions, its report, what it generally says, it cannot be challenged in any court, and this is upheld by a constitution bench. But recently it was in news, because there is a case, that is KC Rathod versus Union of India case, where Supreme Court held that there is no restriction on the court, there is no restriction on the courts to checking the validity of the delimitation orders. If there is any manifest arbitrariness. Same thing what we discussed, doctrine of manifest arbitrariness. KC, that is given, point number 9 in the handout. It is Kishore Chandra Changanlal Rathod. Don't write this in your mains also. Save your word limit. KC Rathod. Now that time nothing you will remember. KC nahi, Rathod nahi, kuch nahi, delimitation bhi nahi. So these are the things with respect to delimitation. Next is whip. So whip is an official appointed by a political party. So if you wish, we can move so fast. So it was because of your unparliamentary whip. So it is he's an official, whip is an official appointed by a political party. And every political party Every political party will appoint its own whip. Every political, but do remember every political party, not every group, not every. Piyush will tell, Aditi will tell, Anmol will tell. Yes, not every legislature party. Legislature party is basically the MPs and MLAs. Political party is organization. So every political party will appoint whip. The objective is to ensure party discipline. So that is why its organization will appoint the whip to ensure the party discipline. The source of authority of the whip. Source of authority. Source of authority. Remember, it is not in the constitution, it is not in any law, it is not in the rules of procedure, nowhere. It is not in the constitution, it is not in any law, statutes, and it is not under the rules of procedure. It is just a parliamentary convention. Next is functions of the whip. Functions of the whip. His first major function is to ensure party discipline. Party discipline. Second, ensure attendance. That is, party members are present in the house. Ensure attendance. Secure support in favor of voting. Secure support in favor of voting. And they also regulate the behavior. Regulate the behavior, especially how the party members, what is their behavior or attachment towards party, that will also be regulated. Next, with respect to securing support of, that is voting, there is 3 different types of whip. Types of whip. This is also convention. One line whip, that is informing the members. Informing the members about a vote. 2-line whip, yeah, it is mandatory for mandatory attendance, yes. And 3-line whip means according to the issues, according to the, according to the line issued by the party. Whatever political party says, you vote accordingly, no other choice. You have to vote according to it, if 3-line whip. Presently, there is no requirement. Presently, there is no requirement for a political party to publish its whip openly. No requirement to publish its whip openly, that is through any newspapers or any other medias. So this is also the reason many times MPs will say or MLAs will say, we did not receive the whip. So there is a proposal for this thing, publish it. Now there is an interesting MCQ trap. The office of whip. The office of whip is not having any backing. No constitutional, no statutory, no rules. It is just convention. But the power of whip is having having a recognition, where it is recognized, anti-defection law. The power of whip is backed by anti-defection law. That means if a member violates the whip issued by its party, if a member violates the direction or whip issued by the party without prior permission, then he can be disqualified under ADL. That is why office of whip is nowhere mentioned, but the power of whip is backed by anti-defection law. Which one? Which one? Yes, yes. Finally, who will be the deciding authority will be speaker. That is a different problem. That is under ADL. But I am talking about the whips. Yeah, authority. Yes. First line even nothing is mandatory. It is just informing that there is a vote. Which one? No, I don't know. You will be knowing. So obviously every political party will set up with their own whip. Yes. Confidence motion everywhere. That time, that is actually the purpose of whip, where you need the attendance of these members. Yes. For what? Minimum time. Minimum time for what? See, that will come under the anti-defection law. Then political parties can take the matter to through anti-defection law, political parties can take the matter, and it is finally the deciding authority speaker. You are saying that, okay, within which period speaker should be informed? No idea. You will be knowing? Generally these doubts are after knowing only. Generally it's not seen anywhere. So you know the answer, you are just, this is something which I am saying that you can avoid it. If you want, you can, but where you got this question? उस पे आंसर नहीं दिया. That is what I never read this across any paper that you asked to inform. See, for example, if there is a prior permission from the whip, then you won't get even disqualification also. In the case of whip issued, but still you are getting a prior permission from the political party or from the whip or the chief whip, then you are exempted from disqualification. That is already there. So that is what, if you are getting, that is cantonment is prior permission. If you are getting a prior permission from this, then you don't need disqualification also. Disqualification will actually happen when there is actually an anti-political activity. That is the original aim of disqualification. Whip is used as a tool to enforce that, to regulate the behavior. No. It is not mentioned. Yeah, power is basically you need to obey the party direction. So that is basically the whip. Next is anti-defection law, continuation of this only. So anti-defection law, first the constitutional aspect, it is under the 10th schedule. It is inserted through the 52nd Constitutional Amendment Act 52nd Constitutional Amendment Act. Then one more thing you should remember, 91st Constitutional Amendment Act. Here itself I am telling you, so that you will get 91st Constitutional Amendment Act. Why it was important? Yeah, it allowed merger but not split of political parties. 91st Constitutional Amendment Act removed the provision of split but allowed merger. How much? 2/3. Now this is an interesting aspect. I'll discuss that, but now if at all I'm like in a flow. See, the merger, what is not accepted is only merger. How much? 2/3 members coming out and merge with a political party. But that doesn't mean that they cannot stand separate. They can stand as a separate political party also. They don't need to, every time they don't need to merge with a political party. They can stand as a separate political party. If that happens, what will happen to the remaining? So who will be disqualified in this case? No one will be disqualified. They can remain as the original political party or whoever, but that political party, they will remain as the, or sometimes, now that is also which is original political party. But in general you see 1/3 political party, 1/3 members of that political party, they will remain as a political party. 2/3 when then separated, they will also remain as a political party. Means in effect, if this happens, nobody loses their membership. Technically there is no disqualification happens. It is just for your understanding. Okay. Now we'll come to the anti-defection law. So anti-defection law was contained in the 10th schedule of the Constitution, inserted by 52nd Constitutional Amendment Act. The objective is to prevent political instability due to defection. Nothing, it is some simple. What is allowed now? Merger. Means if 2/3 members leave a political party, if they merge with another political party, then this is permitted, no problem. But what happens is that 2/3 merger doesn't mean that they always needs to merge with a political party. Sometimes they will remain as a separate political party. Political party bracket some P. Then what happens to this 1/3? They will also be a political party. So nobody loses their party membership, nothing happens. Merger हुआ ही नहीं है, वही है. This is also called as a merger. That every time are you seeing any merger happening? Their separation is happening. They separate and remain another party, and in bracket there will be their old full name, A, B, P, C, D, whatever full name. This will have their full name, C, U, B, T, or whatever. Merger, exactly. So now, though this particular provision is happened, there is this law is, we'll discuss in mains. Okay, this is completely fast. Okay, there is no now speaker is having power, no time limit. Beto? हाँ जी. हाँ. So that is what. That is why I am explaining you. Previously split was only 1/3. Okay, now that word is removed. But technically if they are splitting, but 2/3 needs to be split. Previously 1/3 can move out. Now this 1/3 is not moving out. Which is moving out? 2/3. Technically, that is what I said. कुछ नहीं है. सब कुछ चलेगा. See, that is registration of party rules and all. So that will be decided now. This is another problem. Which is original political party? Yeah. So that is another problem, whether this is original party or this is original party. Now sometimes this is given as original party. They are saying that you are not original party. That doesn't mean that they are disqualified. They will remain as MLAs or MP. Very interesting law. Okay. This is just for your understanding, that's it. Split merger, that confusion you will be having. But actually their split is technically, legally it is not there, but practically it is there, yes. But legally you remember, now don't make that confusion. Sir ने बोला था split था. कुछ मैं नहीं बोला हूँ. नहीं है 91st. No split. No split. मेरा नाम पे मत डालना please. Next is the grounds of defection. First one is related to members of a political party. Related to members of a political party. So a member, if he belongs to a political party, he will be disqualified first if he is voluntarily giving up. Voluntarily giving up. Now here there is a nuance. Voluntarily giving up doesn't mean that it is only resignation. Voluntary giving up doesn't mean that it is only resignation. If this person, if he does any anti-party activities, he is not resigning, but he does everything whatever he wants. In that case also, means if he campaigns for another party, he says that those are very good people, you are fools. Some MPs will do, and the moment such news comes, you know that this person is going to, he is making the 2/3 ready. And the 2/3 is ready, then he will say, मैंने बोला था उस समय, you are too, everybody is fools. Okay, so that is anti-party activity. You don't need always to resign from the political party. It can be anti-party activities or campaigning for another party. All these are also considered as voluntarily giving up membership. This is what Supreme Court also said. Supreme Court said that voluntary resignation doesn't mean only, voluntary giving up doesn't mean only resignation. Next one is voting against the whip. Voting against party. दूध लेके आया होगा. पी लो. Voting against party direction. No whip. Voting against party direction, voting against whip. So that happens, and if the party does not condone it or does not, like, if there is a prayer permission or if the party accepts it, then it is not considered as a violation. So voting against whip, it can be done with prayer permission or if the party condones it or forgives. And here there is a time period, that is 15 days. Next one is, so this is about members of a political party. Second one is nominated members. Class is like over. Okay. Next is nominated members. Regarding nominated members, what is the defection rule? Very interesting rule. If he joins a political party after 6 months. What is the rule of 6 months? Why it is kept as nominated member? If he joins a political party after 6 months. Independent member. If he joins a political party. Independent member if he joins a political party, but nominated member if he joins a political party after 6 months. What can be the reason? What could be the reason? Good, good, good. ठीक है. Correct. Okay. Correct. The core. So next is, next is presiding officer for disqualification. Sorry, who will? What about presiding officer? Presiding officer is exempted. Presiding officer is exempted. Speaker or deputy speaker is exempted if he voluntarily gives up party membership. So they won't be disqualified because it will be considered as a step towards impartiality. Who? Panel chairperson. Presiding officer. See, one thing, presiding officer is generally speaker. He will sit on it because he will act as a tribunal. So he is having the power of a court. Now you are saying that there is nobody, then who will sit? Then somebody will be acting as a speaker. No. See, there is two, you are making a mistake. One is on the floor of the house. To control the house, you need, if speaker is not there, deputy speaker is not there, then you need someone. That is why there is a panel. Another one is office of speaker. Office of speaker is fixed. The person is also fixed. He will be doing it. One is floor. आपको तबीयत ठीक नहीं है. You want to drink milk. You go out. Somebody else will be presiding, right? That's it. That is presiding officer. Whoever is presiding the house. इधर क्या है? Basically, the presiding officer in the case of defection is who? Speaker or chairman of Rajya Sabha. I understood your question. If nobody is there, right? नहीं होगा ना. Speaker is must. There is a speaker.
The panel of chairperson, if they are presiding, so they can resign from the party.
No. These are only the speaker. You select someone as speaker. You select someone as deputy speaker. They are the responsible speaker. But to manage the house, sometimes you will appoint. आप बैठो मुझे कोई काम है. Sometimes you can see somebody else on the chair. They are not speakers. Means you are saying that that person who sits on the now is I won't leave. I'm speaker. No. Speaker is, who is speaker of India? Who is speaker? He is the speaker. That's it. But sometimes you can see somebody else sitting on the chair. That is possible. That time he will be the presiding officer. But decision will be taken by speaker. So every time a new presiding officer comes, he will say that I am voluntarily giving up. Next time he goes, new person comes, no. Deciding authority. Speaker is the deciding authority and his decision is final. However, Supreme Court said that speaker will act as a tribunal. That is why the speaker's post is very crucial nowadays. They will always look for a speaker's post. In Maharashtra also there was a great deal of debate with respect to getting that speaker's post. So you need that office, that speaker as a very critical person. You won't give that post to anybody now. नहीं मिलेगा. ठीक है? So who decides? Speaker, but he is the final authority. Yes, final authority, but he will act as a tribunal, so it will come under the purview of judicial review. So these are the things. Okay, next is there any time limit for speaker? No time limit, but court said that it should be taken up as early as possible, and this as early as possible is considered to be maximum 3-month period. So these are the things. Now come to next topic, that is judiciary. Sorry, one more thing, disqualification under RPA. So in some class we discussed what is the difference between RPA 1950 and RPA 1951. What is the difference? What is the difference? 1950 and 1951. What is the difference? 1950 is, yeah, electoral rolls, that is pre-election. This is conduct of election, which also handles with the disqualification. It also talks about the disqualification aspect. So RPA 1950 is basically pre-election or preparation of electoral rolls. This is actual election, conduct of election, which also deals with the disqualification. So under RPA, so 102, everything, I hope everybody knows article 102 and all. So that basically deals with the disqualification under the constitution for MPs. And similarly 191 deals with the state assembly. And 102 also empowers parliament to make laws prescribing additional ground for disqualification. 102 also empowers parliament to prescribe additional grounds for disqualification. Based on that, it is given under RPA 1951. RPA 1951. Okay. So under RPA 1951, section 7 to 11, section 7 to 11 details about disqualification. Section 7 to 11 we finds the disqualification details. So if any person is falling under the categories, then he is basically disqualified. So the major section is section 8. Section 8. First one is section 8 clause 1. Section 8 clause 1. What is that? If a person is convicted of any offense given in section 8. Here the term you should remember, it is conviction. It is not like 130th amendment bill which talks about arrest and detention. So if a person is convicted of an offense under section 8, then he will be disqualified for 6 years plus the period of sentence. period of sentence. That is the first one, section 8 clause 1. Next is section 8 clause 2. So here there is one more thing. If he is disqualified, if he is convicted for or just convicted, if he just fined, then his disqualification will be a period of 6 years, whatever be the offense under this. But if he is convicted for a particular sentence, for example, he is convicted for maybe 1 year or maybe 4 year, whatever, 4 year, then 4 plus 6, he will be disqualified for 10 years. Or in 1 year, it will be 7 years, like that. Now section, this is 1, 8 clause 2, section 8 clause 2. That is for economic offences and all, like Dowry Prohibition Act, social offences or economic offences, adulteration, all these things will come under 8 clause 2. 8 clause 1 basically comes under heinous offences. This is for heinous offences, serious offences, rape, murder, or also it deals with electoral offences, bribery, or even promoting enmity between groups. Untouchability will also come under 8 clause 1. Next is section 8 clause 2, that is economic and social offences, which include economic offences like hoarding, profiteering, adulteration, and social offences like dowry prohibition. He is disqualified, same thing, conviction plus 6 years. Now section, this is the reason now it was in mainly news, section 8 clause 3, for all other offences, which is not in 8.1 and 8.2, all other offences, and if the conviction is more than 2 years, imprisonment or conviction is more than 2 years, then he will be disqualified for 2 years plus 6 years. Previously there was a clause, that is 8 clause 4, which gives some space for the members, MPs, MLAs. That means if they appeal against the conviction, then they don't need to, or they are not disqualified. But that is not there. Anyway, you don't need to remember this. Lily Thomas case, Supreme Court held 8 clause 4 unconstitutional. Now it is struck down. Supreme Court struck down 8 clause 4 in Lily Thomas case. So now there is no appeal clause for MPs or MLAs. So they will be disqualified immediately upon conviction. Immediately upon conviction means if they are convicted more than 2 years, then it is, immediately they will be disqualified. However, there is an escape clause under section 11. Section 11, there is an escape clause, that is Election Commission of India, ECI, has the power to remove or reduce the period of disqualification. ECI has the power to reduce or remove the period of disqualification. Huh. Specific? For what? Holding disqualification means what? No, no, no. I don't think so. By-election will happen. He is saying that within which period it has to be notified. Anything. Sometimes it is extending more than 6 months also. Hmm. No, that is because see that option is there. That option is there. If there is a like stay you are getting on your conviction, then you are reinstated. It is only on like conviction, and if you are not getting any stay, then automatically you will be immediately you will be this thing. Huh. Which are the corrupt practices? Which confusion? Section 8. Some are given under 9 also, I think. 10 also, I'll just tell you. It is given, 9 is given about disqualification for corruption. Then that's it. 10 is disqualification for office under government company. Disqualification, then there is 10A, disqualification to lodge election account expenses. That is 10A. Next is judiciary. So first one is removal of judges. It is the important topic for you from judiciary. So this is in the context of Supreme Court itself is recommending the removal of a judge, High Court judge. Now first one is what are the articles, constitutional premise, articles of the constitution which deals with removal, that is 124 clause 4 and 5. Similarly, article 217 for High Court. A High Court judge is also removed in the same manner and same ground as Supreme Court judge. Second key aspect, as per the constitution, grounds of removal. There is only two grounds. One is proved misbehavior, second one is incapacity. There is only two grounds, proved misbehavior or incapacity. This you remember. Here you may get some trap questions. Now the procedure is regulated by, the procedure for removal is regulated by Judges Inquiry Act 1968. Judges Inquiry Act 1968. There is no word impeachment used in the constitution. There is no word, impeachment word is not used. Now we will go to the same model like we have discussed, a sequential order. sequential order. So the process starts in court or parliament? Okay. But the process in-house procedure, this I'll discuss. In-house procedure starts in court. This does not have any statutory backing. But according to the Judges Inquiry Act, the process starts in parliament. That is having a statutory backing. So according to Judges Inquiry Act, the initiation of the process starts in parliament. First is motion, notice of motion for removal of judges. First one is notice. Notice for removal of judges. In the case of Lok Sabha, it requires the signature of 100 MPs. Rajya Sabha 50 MPs. Second step. So first one is notice of motion. Second is admission. Admissibility. Second is admissibility. So admissibility. So just because MP signed a motion doesn't mean that the investigation or the process completely starts. The speaker or chairman of Rajya Sabha will act as a filter. So there is a filter mechanism. So the speaker or Rajya Sabha chairperson will act as a filter. Act as a filter. They can admit the motion or refuse. So what they will do is they basically consult the relevant experts or persons and the materials, then they will take a decision. Step 3, constitution of a committee. Step 3 is constitution of a committee. So if the motion is admitted, then investigation will start. And this investigation committee or inquiry committee will have 3 members. Inquiry committee will have 3 members. So one will be Chief Justice or other judges of Supreme Court. Or Chief Justice of High Court, and also one jurist. Distinguished. One jurist. So one judge, one Chief Justice and one jurist. And if the notices are given on the same day to both the houses, then procedure will start accordingly and the committee will be jointly formed. Sometimes what will happen? It may be first in Lok Sabha, second in Rajya Sabha. So wherever it is first submitted, that will be considered. The notice can be submitted in Lok Sabha, Rajya Sabha, or submitted the same day in the same houses. Then if that happens on the same day, then the committee will be constituted jointly by both Lok Sabha and Rajya Sabha. If not, wherever it is first submitted, they will constitute the committee. Then comes fourth step is investigation. So the committee will act as an investigation committee and it will have the powers of a civil court. And the judge will be given right to defense. Judge will be given the right to speak, right to defend, to ensure natural justice. And if it is based on a incapacity, then a medical board will be created. If it is, the reason is incapacity, then medical board will be created. Fifth step is report submission. Fifth step is report submission. Investigation will submit a report to the speaker or chairperson. If found guilty, then the process, again it will proceed the process. If not guilty, the process end. It ends. If found guilty, then the process will continue. If not guilty, the process will end immediately. Means no further step will be taken by the parliament. Now in this case, if it is guilty, then comes the sixth stage. Otherwise, up from the fifth stage, everything will be over. Sixth stage is parliamentary voting for removal. Parliament vote for removal. So if the judge is found guilty, then a motion must be adopted by the House. So what is the condition? Yeah, there should be a special majority. Special majority. What is a special majority? Yeah, majority of the total membership and majority of not less than 2/3. Special majority. And the removal must be presented to the president in the same session in which the motion is adopted. The removal must be presented to the president in the same session in which the motion is adopted. So here there is a trap. One is investigation process, second one is removal motion. So that is here. This should happen the same session, but investigation can happen in two different sessions also. Investigation is continuing, one session ends, but that doesn't mean that everything is over. Investigation can continue. The process of investigation, this process can continue in different sessions also, but if the motion is adopted, then it should be passed by the president, by the parliament, and submitted to the president in the same session. Understood? Okay. So is violation of constitution a ground for removal? That is not there. Only two things: proved misbehavior and how it is? Yes, through a motion. It will, everything in process will be a motion or a solution. That's it. No, over. Chairman can deny it or speaker can deny it. Speaker will consult stakeholders and based on the speaker can deny it also. That I'm coming to that. Next is the in-house procedure. in-house procedure is adopted by the Supreme Court. Adopted by the Supreme Court to inquire into complaints against judges, so the process is, if the complaint is serious, the CJI forms a 3-member committee. Three-member committee, and if the committee finds guilt, then CJI may ask the judge to resign. This is actually safety valve. If the committee finds guilt, the CJI may ask the judge to resign. And if the judge says, manega nahi, then CJI will inform the president. And Prime Minister to initiate removal proceedings. So that is what happened in Verma's case. There was an in-house mechanism, and the in-house they found a guilt, and the matter is now referred. So in-house, remember that it is not a statutory committee. In-house committee is not a statutory committee. What is the nature of the committee? It is just a fact-finding committee to see whether there is any substance, merit in the case. No. But that is a statutory mechanism. So you are actually if this fact is correct, then automatically what is going to happen is that he will have to go through the process and he will be removed, because the next committee will also find the same thing. See, this is basically safety valve. It is a fact-finding mechanism where the court is ensuring that yes, there is a merit in the case. Court is giving an opportunity, you resign. Then they'll get some pension and other benefits. If not, you go through that and it will be removed. In India, no judge is removed. Then also committee will be formed with the senior most judges. That's it. No, then both will jointly appoint. But the committee will be jointly up. If the motion is submitted or the notice is submitted same day in the same house, then both will jointly. Otherwise, whoever got the first, they will constitute. No. Yes. He always acts on the aid and advice. President's case is very much settled, because there is an amendment also. आपको कुछ option नहीं है. Aid and advice. Governor, there is a option, but in that there is amendment and said that everything will be done by the aid and advice. President case settled in law. कहाँ? In house में. So there will be one like 2 judges from the High Court side. One will be, whatever depends on the allegation of the judge. If it is Supreme Court, then it will be accordingly. If High Court, it will be decided accordingly. Okay, that's it for today. There are few things. I think better there. You only the reason for all these things. Okay. So just I think 2-3 or more are there, and then there are constitutional bodies. So like this, you are okay, right? If there is any problem because of the pace, or tell me very frankly, because I saw some students sleeping, very demotivating. You are sleeping? Okay, tell. Pace Slow. Ah.